Last podcast, we talked about Alex failing his polygraph. In the motion, the government requested that the documents about the polygraph be sealed. Today we have some new motions by both sides. One of these documents was filed twice, so Dick and Jim must mean business. Let's get started. This is Legal Updates with Cassidy. To seal or not to seal. Chris Wilson described as participating in the conspiracy. Welcome. Before we begin, I want to say so far his hearing is still set for the 1st. We have several motions here, so let's jump right in. We'll start where we left off, which was document 65, where the state requested that the polygraph information be sealed. There is an order, which is document 66, but it is sealed. But it does sound like the court might have ordered the seal based on these next filings. In the state's document requesting the seal, they stated the reasons very clearly. It relates to an ongoing grand jury investigation, as well as allegations of criminal activity against others. Yet, we find on the first page of this document defense's objections. They claim that it does not comport with Local Criminal Rule 4901. So this motion should be denied because redaction would be sufficient. They say the information has already been disclosed to the public, and they also state that Alex denies the allegation that he breached the plea agreement by failing his polygraph. They also state that the public has a right to know the truth of the matter through judicial proceedings that are open and transparent, not closed and sealed. They say that allowing the government to publicly accuse Murdaugh of breaching his plea agreement while also allowing them to hide all the evidence supporting that accusation violates the public's right to the truth. They then delve into the details in point 1, where their first accusation is that the government's motion doesn't comply with Local Criminal Rule 4901. But a quick glance at Rule 4901 shows otherwise. They focus on A1 while ignoring the footnote, where the first exclusion is, guess what? Material relating to grand jury proceedings or investigation. So not a great start here because this is exactly what the state used as the reason for the sealing. Instead, they focus on the rules we see about what a party must do in order to request a seal. And all of these are of course true if you're going to completely ignore the fact that this is material for a grand jury investigation, which makes all these arguments moot. So these paragraphs and pages are a waste of everyone's time. So is point 2 because it continues the argument that redaction is sufficient. But again, grand jury investigation, guys. They state all manner of argument about the process of sealing a document, that the party must state the reasons for doing so. They did. Grand jury investigation. Their reasons for rejecting alternatives, and then on to the fact that Corey and Russell's trials were widely publicized. 2 things about this next paragraph. Corey's name is spelled C-O-R-Y, Fleming, F-L-E-M-I-N-G. And Lafitte is spelled L-A-F-F-I-T-T-E. These kinds of things drive me crazy, but besides that, it doesn't matter that their trials were widely publicized. They are not over. They are both currently in appeals. Corey is appealing his state sentence. Lafitte is appealing his federal sentence and also still delaying his state trial. So this is not just about Alex. These things matter, and you can bet if it were the other way around, they'd be screaming for Alex's info to be sealed from Corey or Russell's hearings if it were the other way around. They end by saying the upcoming hearing would have to be sealed as well if they want to keep these things sealed, which would rob Alex of the right to a public hearing. So we'll be waiting on the court's answer to this. Next, we have the 2 sentencing memoranda, and since defense filed first, we'll consider theirs first. They start off by victimizing Alex, saying they're going to discuss the applicable guideline provisions imposing a concurrent sentence with the undischarged state sentence Murdaugh is currently serving for the same conduct. They also want to address the government's late-filed motion contending that Murdaugh breached his plea agreement by failing to pass a polygraph administered by the FBI. and they state that a full evidentiary hearing where Alex can confront the polygraph examiner would be necessary to address the government's assertion that Murdaugh failed a polygraph examination. And then here we go. There are legitimate questions as to whether the government intentionally manipulated the results to void the plea agreement and achieve the prosecutor's stated desire to ensure that he's never a free man again. So now they're claiming it's not just SLED, it's not just Becky, it's not just Judge Newman, it's not just the jury, it's not just the local police, it's not just Creighton and the Attorney General's office, but now it's the FBI that are just out to get poor old Alex. What's next? The CIA? MI5? James Bond? Darth Vader and his squad of stormtroopers? I mean, come on. Stop blaming everyone else but murdering, thieving Alex Murdaugh. These people did not all just come together and try to set him up. That makes no sense. Claiming that this is the state of South Carolina's federal government doing this when it's the FBI that actually carried it out is just a ridiculous accusation. So here, they vilify the FBI agent and call his conduct odd. When dealing with liars, law enforcement often uses tactics to relax or distract, such as claimed here. The agent asking Alex if he can keep a secret and disclosing that he had just polygraphed Vandersloot, the guy who murdered Natalie Holloway, is attempting to do that. Does anyone remember the Chris Watts polygraph where the investigator got him relaxed, presented a possible excuse for the murder to see where it went? Do you remember she said, maybe Shanann hurt one of the kids and you reacted? And then she left, and right away what did he decide? He started telling the lie that Shanann had killed the girls, and he flipped and killed her. These are simple tools that law enforcement uses, especially when dealing with a person like Alex. Alex should be accustomed to such thing. For one, he was an attorney for decades, and two, he's a well-known liar. He knew just how to lie to all of those people in his life that he was lying to. So spare us the poor Alex defense. Then they complain that the government has not given them the charts to have them examined by an expert to see if the government accurately scored the results. It just makes me remember their so-called experts at the murder trial compared to the FBI, who does this constantly. Either way, they may have a point here about that, so I will concede this much. Next, they argue points about his charges and whether they should fall under concurrent or consecutive sentencing. Here they try to say that the calculation of his criminal history is off, claiming that some of these things fall under the same crime, so their sentencing should be grouped together. I won't go into a lot of the details of this just for the sake of time. But after attempting to make their points about this, they conclude this portion by saying that Alex is serving 2 life sentences without the possibility of parole for his murder convictions, so there's nothing to be gained by imposing a consecutive sentence, saying that he'll die in state custody and never serve a day of consecutive time. If Murdaugh's murder and related convictions are vacated on appeal or through a federal habeas action, then there will not be any active sentence with which to run consecutively. Then we get into the loss amount. The reason this is important is that the amount of theft is separated by different brackets. The more you steal, the higher the fine and longer the sentence you'll receive. If you're in a smaller bracket, the sentence is shorter. So they're saying that the amounts tallied by the government are incorrect and that this is why. Their first argument is about the Ferris fees, and if you'll remember from the trial, the Ferris fees were the first clue that something was wrong with Alex's numbers at the firm. The amount that Alex stole in Ferris fees was $792,000, but they say this should be dropped, because before the scheme was detected, Murdaugh returned $600,000 to that law firm so that Wilson could pay it to his law firm. And then Wilson loaned Murdaugh $192,000 to bring the number total, and so this full amount was paid to PMPED. And also they claim that the remaining loss is overstated because loss is defined as the reasonably foreseeable pecuniary harm that resulted from the offense. And that means harm that is monetary or otherwise is readily measurable in money. And so the total amount of fees that Murdaugh diverted to himself is not an accurate measure of pecuniary harm to the firm. We'll get to the state's reply to this. This is an incredible statement. It truly is. Some of these statements are just, I can't think of a better word than incredible, because they're beyond belief that they would come up with these reasonings. For example, here, they say each partner was entitled to a year-end distribution of 92.5% of the total fees the partner earned through the firm, and that Alex collected sufficient funds to cover his share of the firm's overhead every year that he was stealing, and that he would have been entitled to receive at least 92.5% of the amounts, and I like how they say diverted instead of stolen, so therefore they figure the loss is only 7.5% of the diverted amount. So, in the table where they were coming up with how much he stole and so which bracket he would be in, when it came to his fees from the firm, the total was $1,481,935.49. But their way of reasoning is that, well, Alex was entitled to at least 92.5% of that, or $1,370,790.33. Therefore, if you subtract the fair's fee which got paid back, it's reduced to only $51,745.60. So with this fancy math, he goes down from level 20 to level 18. So they're saying that with this fancy math, it should reduce his amount of sentencing. That being said, though, the damage to the reputation of the law firm cannot even begin to be calculated. But we're also going to look into the state's response to this. Just keep this outrageous claim in mind. Now we're back to poor, persecuted Alex. Those mean old prosecutors declared to the press that the reason Murdaugh was federally prosecuted was to ensure he's never a free man again, and that this statement was made even though pursuant to the plea agreement, the prosecutors agreed to recommend to the court, consistent with the federal sentencing guidelines, that the federal sentence run concurrently with his state sentence. Then they say that it was a follow-up conversation about this, that Alex's counsel themselves was advised that Alex must pass a polygraph examination to obtain the benefit under the plea agreement. These kind of statements are often made by prosecution when putting a criminal behind bars. It's called justice, which is what they fight for, and there's nothing wrong with prosecution wanting a bad guy behind bars. But this last sentence is just completely wrong. The polygraph statement is pretty standard in these federal agreements. It's not something that was set up to trap Alex. It's not something that just came up in the follow-up conversation. It's standard. And if they had objections to it, they should have done so at the time, but under their advice, Alex signed it. And now they lay it on thick. Poor Pollyanna doesn't understand the term hidden assets. They make the claim that after conducting 4 interviews with Alex over a 6-month period, prosecutors demanded that Murdaugh submit to a polygraph examination regarding his assets. That was in the agreement all along. Why did it come as a surprise that they asked him to submit to a polygraph? And they claim that it was very curious. Are they serious right now? How many times has this subject been brought up? It's a constant theme surrounding him, and many of us believe he has money stashed. This is not a new concept. In fact, at his state sentencing hearing, Mark, the Tiger Tinsley, directly put this question to him and told him they were going to continue searching for these funds. Watch his face in this video.
You asked about Eddie Smith. Eddie Smith was a check cashing scheme. Eddie Smith was being paid to cash checks, but that money is still out there, and he knows where it is. He didn't spend all that money on drugs. If he wants to be accountable, he wants to be contrite, he ought to tell these people where their money is. That's not going to happen. The same as he's not going to lay in bed at night and think about the wrongs and feel sorry for what he did.
He knew exactly what Tinsley was talking about. We all did. We see his face start to turn pink. We see the murderous anger in his eyes. This question was being put before him. He knew that forensic accountants had been pouring through his stuff for a couple of years now, since November 2021. So Alex saying that he'd never been requested to identify his assets is nonsense. And $6 million? $6 million missing dollars? It's not something that just got lost or overlooked somehow. He knows exactly where that money is. He was just shocked that he'd been discovered and panicked. He thought it had ended when the receivers had come up with the amount that they'd come up with at the end of last year. He thought he got away with his stash, and he panicked. He didn't panic because it was the first time someone had suggested that he might have hidden assets. And as a lawyer, he should certainly understand the term hidden assets. Next, they object to the method in which questions were asked. But it does make me wonder, they claim they don't have a record of the polygraph files, so how do they know how these questions were asked? I'll have to hold off on my opinion till we see the questions, but if they directly asked if he had funds stashed somewhere, what's wrong with that? Or if they asked did he have funds that had not been disclosed or found, what's wrong with that? These are relevant questions. But they state here that the examiner's questions run afoul, and then they list the standards for designing polygraph questions. But again, we'll have to wait till we see the record to determine whether or not they followed these standards. Then they make the claim that the polygrapher designed the relevant question in such a way to ensure that Alex would fail the exam. Now remember, this is the FBI, not the state, not SLED, the FBI, but they did it in an effort to accomplish the prosecutor's stated goal of ensuring that he will never be a free man again. Because we all know that the FBI takes orders from United States attorneys in South Carolina. Then they talk about his odd questioning. Again, the examiner upon meeting Alex exclaimed that he did not believe Alex murdered his wife and son. Remember, these are the tactics used by law enforcement. It's not illegal. The examiner also inquired who Murdaugh thought killed his wife and son. In response to this inquiry, Alex asked the examiner to polygraph him on his wife and son's murders. The examiner refused. I kind of wish they had. But these guys are not there to make friends with Alex. They are well trained in the art of tracking deception from lying criminals. They use all sorts of methods from seeming friendly to accusing to anywhere in between. You can't sit there and blame every single law enforcement division or legal representative or judge of simply having it in for poor old Alex. They're doing their jobs to accomplish justice. They go on to repeat their claims that the state refused to provide them with the results and that this deprives Alex of his opportunity to present an expert and it denies his right to cross-examine the polygrapher. Again, we'll be awaiting hearing what the court decides about this accusation. Then they spend some time focusing on the fact that the court should not rely on the polygraph as a so-called lie detector. And this goes with their objection that he breached his part of the plea agreement by failing the polygraph. Now this part is interesting, and I will give them this. They say the polygraph examination took place on October 18th, and there was a final review of the results by October 26th. But the government waited 5 months before filing its motion, barely more than 2 business days, and it was in the late afternoon before sentencing. So they claim that the government engaged in deliberate delay to impede careful judicial scrutiny of its position. Like I said, I'll give them this. 5 months is a long time to wait to file these results. Unless there's some reason for it, this should be considered. But after giving them that, they completely lose me again on this claim. They're saying that there's no basis for this upward variance that was filed last week. And then they list the reasons that are allowed for an upward variance. But right there in amongst them is defendant's conduct was unusually heinous, cruel, brutal, or degrading to the victim. Do we not consider Alex's conduct to meet this? I do. And then I became completely enraged, as I always do when they use his opioids as an excuse for his conduct. As I always say, how does drug abuse excuse crime? It is not an excuse. It's just an additional crime. I dare say a lot of criminals are on drugs, and never, ever does their drug use excuse their conduct. It's simply an additional criminal act, and it's enraging that they again say, as egregious as Murdaugh's criminal conduct was, his misconduct must be viewed along with his 20-year severe opioid addiction. No, it must not. It's just an additional crime. Also enraging is the last paragraph, where they say, brace yourselves, okay? This is bad. The clients from whom he stole, who are vulnerable victims, have been fully reimbursed for their financial losses. Many have even recovered more money through threats of litigation than they ever would have received if Murdaugh had not stolen from them. These reimbursements were made by Murdaugh's former law partners, who obviously cannot be considered vulnerable, the law firm's insurance carrier, Palmetto State Bank, and other third parties. Can you believe this? So because others paid for his thievery, and it was people who can't be considered vulnerable, all is well. And Alex's thievery actually helped them because they got more than what he stole. Can you imagine what these insurance companies and the bank and the partners and these third parties who had to come up with millions to pay back what Alex stole? Can you imagine how they feel hearing this? And even more, how the victims who suffered for years before getting their money, being told all is well because they finally got it? What about the ones who were raising children? Their children did without for years and years in some cases. You can't give them back a different childhood with better opportunities by giving them money now. And not everyone has been made whole. Just because some have gotten more than they lost doesn't mean that's true for everyone. But again, them saying that many have even recovered more, what, is Alex some kind of hero? Are they supposed to be grateful? And then they conclude this poisonous document by asking for the sentence to run concurrently and not consecutively. Absolute gall. So now we get to the state's sentencing memorandum, and they begin by saying that the objections to the loss amount and criminal history calculations do not have merit, and that they're waiting on the court's resolution to the motion holding Alex in breach of his plea agreement. And then they do admit in the footnote that if the court does not find that he breached it, the sentence must run concurrently, as agreed. Here we find some interesting wording. They list Chris Wilson, along with Corey and Russell, as participating in the conspiracy. It says the pre-sentence report found he stole from more than 10 victims as a part of his role in leading and or organizing a jointly undertaken criminal activity with Russell Lafitte, Corey Fleming, and Chris Wilson during their participation in the conspiracy. This really sounds like they're naming Chris Wilson as a part of this conspiracy. But this paragraph also shows the criteria that they used for coming up with their calculations, and that the fact that the people who paid back his victims were not vulnerable does not change the fact that the people he stole from were vulnerable. It's such an outrageous way of thinking. They next address the claims that the fares fee shouldn't be included because it was paid back before it was discovered. We saw that in the motion that they filed. Let's review this. It walks us through the case again that it was a personal injury case that Alex and Chris Wilson pursued together. They obtained a large recovery. Wilson's law firm paid Alex's law firm directly for expenses incurred on the case, but PMPED never received a check for Alex's legal fees. Alex admits that this money was diverted to himself. Now remember, in the defense's motion, they say the fares fee shouldn't be included because it was paid back before it was discovered stolen. But let's review the facts. It was in the spring of 2021 that the law firm first started to ask questions about the missing fee. And at the time, they were afraid that Alex was trying to hide assets because they knew about the impending litigation for the boating accident. But it came up again. They started questioning him about these missing fees. On June 7th, that fateful day, we know that Jeannie Seckinger confronted Alex about it. Their conversation was interrupted by a phone call about his father being hospitalized. So the conversation was dropped, and that very night, Alex killed Maggie and Paul. The very next month, July 19th, Wilson emailed Alex to confirm that he had received that $792,000. Then in September of 2021, after PMPED uncovered Alex's decades of theft, that's when Wilson paid the law firm the $792,000. Alex claims that this $792 should not be attributed as a loss because it was paid back, but we saw the law it has to be returned before it's discovered, and clearly by looking at these dates, none of this amount of money was returned before it was detected. Therefore, this objection should be overruled. And here we see the law. It clearly states, the loss should be reduced by money returned by the defendant to the victim before the offense was detected. This was simply not the case. But rather, the only reason the money was paid back was because the law firm had detected Murdaugh's diversion of funds. He was confronted on June 7th. Alex paid it back into Wilson's trust after that confrontation, and after months of the law firm trying to find it, and it wasn't until September that Wilson paid PMPED, well after Murdaugh's crimes were uncovered. And as far as saying that the fees that Alex stole from PMPED, that he would have earned 92.5% of them anyway, so it's not really stealing, the government intends to call Ronnie Crosby, who was a partner at the law firm. Many of you will remember him for testifying during the murder trial. He is one of the partners that had to hand over millions of dollars to cover Alex's theft. And he will testify that Murdaugh breached the employment agreement and therefore was not entitled to keep any portion of those stolen fees. And it's just a ridiculous way of thinking. Well, they were going to owe me anyway for my legal fees, so they can't count the full amount. But just imagine if a cashier took money out of her till because she was going to be paid just a little bit less than that anyway and thought that she could just put it back months after being caught. How would that go over? Does anyone think that's okay? How is it any different what Alex did? How dare these lawyers try to bend the law like this? You can't steal money because you think you'd be owed that anyway. But further, Crosby's testimony is going to establish that when the firm did uncover Alex's thefts, they immediately confronted him. He resigned, terminating his employment agreement. And guess what happened? He did not receive any distributions that year. And then the law firm spent millions repaying his victims. So his erroneous thinking that he was owed those funds is wrong, because once you break the employment contract, you're no longer entitled to those. So of course these funds should be included in his sentencing. They were stolen. For the sake of time, I'm skipping over the arguments about Alex's crime scores, just like I did with the defense's motion. His defense had argued that some of them fall under the same description, and the state here cites laws showing that they do not, and therefore cannot be grouped into the same sentencing. Also, for the sake of time, we're going to skip some of the portion pertaining to Alex's claim that his crimes don't call for an upward variance. But if you remember, in the law itself, it says that crimes that are especially cruel or heinous qualify. So in this section, there's a long portion of the history of Alex's crimes and the means in which he committed them, things like his forge account, using Russell in the bank. These are all well known, and I've covered them extensively here on my channel. So we're not going to take the time to go through each of those, because they do walk through several of the most well-known victim stories, such as the Satterfields, the Badgers, and the Pinckneys. But this right here caught my interest. It began at least September 2005, so it's much earlier than originally thought. Originally, we thought this started around 2011. And as it said, Murdaugh's scheme evolved over the years to avoid detection and capitalize on every opportunity to increase his cash flow. And yet they're saying, oh, well, he doesn't deserve an upward variance. That's just for the especially cruel and heinous people. And I'm really glad they said this next statement. He even goes so far as to claim that in light of their financial recoveries, the victims are better off now than they would have been had he not stolen from them. And here's the truth. Murdaugh has never made his victims whole, financially or otherwise, nor has he made any efforts to do so. This court should not give him the benefit of others bearing the financial fallout of his crimes. And this is so true. Alex is happy to sit there and say, well, these other people paid you. It's not the same. They didn't steal. He did. Why should others have to pay his debt? How dare he sit there and be satisfied that others are paying it? Now, also right here in the document, there's a long list of victims that are identified only by their initials. I want to cover that in a separate podcast. But they state that there were 25 total victims, many of which never pursued anything or never came forward. So we're going to go through those stories of the unknown victims in my next podcast. Then under the history and characteristics of the defendant, they say the scope and pervasiveness of Murdaugh's deceit is staggering. He ranks as one of the most prolific fraudsters this state has ever seen. And then at the end, they mention the $6 million in stolen settlement proceeds that remain unaccounted for. Also erroneous was the statement that all of his victims had been made whole. And we can see here, it says Murdaugh was not convicted of or sentenced in state court for any conduct related to 11 victims outlined above. And it gives their initials, saying that the loss associated with those victims alone is nearly $1.3 million. If Murdaugh were to be sentenced solely on that conduct, his applicable guideline range would be 110 to 137 months. So them claiming he doesn't deserve an upward variance? Erroneous. He's not even being charged for all of his crimes by all of his victims. In addition to the harm he caused his direct victims, it also mentions that he sowed seeds of distrust in the legal profession, the judiciary, and the banking system in South Carolina and across the nation, and that his sentence must reflect the seriousness of his conduct and provide just punishment for it. This is a strong point as well. While defense is trying to minimize his sentence, we now see here that he's not been convicted or sentenced for 11 victims, totaling over $1 million. So focusing on all of this damage he's caused, they ask for sentencing to fit his crimes. And so this brings us to the end of all the documents that were filed today. I am expecting to hear an announcement tomorrow, since court is scheduled for Monday, and there seem to be some decisions that will need to be made by the court before that hearing can take place. So unless they're decided tomorrow, we may see a delay for that hearing. I'll be on the lookout, and as always, will keep you informed. Till then, this is Cassidy O'Connell saying stay well and stay tuned.